Trump is running out of time, a New York judge just shut down his final attempts to avoid paying a massive $464 million bond. During a private emergency court session on Thursday, January 23rd, Judge Arthur Engoron made one thing crystal clear: Trump has no options left. People who were in the courtroom say the judge repeated the word final 3 different times while turning down Trump's lawyers' newest requests to delay or lower the payment. This is not just another legal bump in the road. This is the point where every door Trump's team tried to open got slammed shut by a judge who's done waiting. When a judge tells your lawyers that no more delays means exactly that, you know the situation just got very serious. Make sure you subscribe right now so you don't miss what happens next. So what caused this dramatic moment in court? Reports suggest Trump's legal team filed what sources describe as their 7th request in just 3 weeks, trying once again to reduce the bond, push back the deadline, or use different types of payment. According to multiple lawyers who were there, the judge's answer was direct and left no confusion. He explained that Trump had already been given several chances to find the money, that higher courts had already decided on the amount, and that any more delay requests would be seen as blocking the legal process. This isn't ordinary courtroom back and forth. Legal experts say this shows the judge signaling that time has run out. And trust me, when judges start saying things like the court's patience is finished, something major just happened. Let me give you the full story of what's been going on. Problems between Judge Engoron and Trump's lawyers have been growing since the $464 million ruling came down on February 16, 2024. That decision found Trump guilty of lying about how much his properties were worth, inflating values by billions to get better loans. But things got much worse on January 18th when Trump's attorneys filed another emergency request, saying no insurance company would accept his buildings as security for the bond. Judge Engoron's response during the January 23rd hearing hit hard. He pointed out that Trump had publicly bragged about having over $400 million in cash just weeks before at campaign events. The judge said Trump's team was basically asking the court to believe their client either lied to voters about his wealth or was lying to the court about not being able to pay. Hit that like button if this is starting to make sense. Here's where it gets really serious. When Judge Engoron looked at the latest money documents Trump's team submitted, he noticed right away that the numbers didn't match up. Sources from the court say the judge spent nearly 12 minutes carefully comparing what Trump said publicly about his available money versus what was being claimed in court papers. Let's be real for a moment. Judges demanding full bond amounts without any reduction is very rare in big civil fraud cases like this. It doesn't happen because of small mistakes or paperwork errors. It happens when judges believe someone has been trying to manipulate the system and probably won't follow any judgment voluntarily. Here's what several sources familiar with the hearing say happened next. On January 23rd, a private meeting was held in Judge Engoron's office with top lawyers from both sides. Trump's legal team presented what they called their last attempt to get modified bond terms, including letters from 4 insurance companies saying they wouldn't accept real estate as security. Sources told CNN that Judge Engoron listened to the 20-minute presentation without stopping them. Then came his reply. According to 2 attorneys who were there, the judge said, "I've looked at these letters. I've also looked at your client's public statements about his cash reserves and total wealth. These 2 things don't match." Trump's lawyer, Christopher Kise, tried to speak up, but Judge Engoron stopped him. "Counselor, your client has choices. Sell properties, find different financing. What your client cannot do is claim he's wealthy when it helps him politically while claiming he's broke when bills are due. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. The second Judge Engoron finished that statement, Trump's lead attorney Alina Habba stood up and asked for a short break to talk with her client. The judge said no. He explained that the court had given more than enough time for the defense to prepare other options and the meeting would continue. What happened next was described by lawyers present as almost unheard of in New York civil court cases. Judge Engoron laid out a schedule with exact dates and exact consequences. He stated that Trump had until 5 p.m. Eastern Time on Monday, January 27th, to either post the full bond or provide proof of a guaranteed agreement with an insurance company for the complete $464 million. If that deadline passed without compliance, the New York Attorney General's office would be authorized to immediately start taking action. That means seizing assets, putting claims on properties, and potentially freezing bank accounts. The judge made it completely clear there would be no more extensions, no additional requests for reconsideration, and no emergency appeals that would stop enforcement. This announcement sent shockwaves through legal circles and Republican political groups. When a judge with Judge Engoron's reputation for careful procedure starts setting hard deadlines with instant consequences, it means the normal negotiation process in civil cases has ended. Legal analysts noted that the judge's words removed any confusion. Arguments that this is political targeting or partisan unfairness fall apart when you examine the actual record. Trump's team has filed 7 motions in 3 weeks. The judge has reviewed financial documents, insurance company letters, public statements, and campaign finance reports. The pattern he found wasn't bias, it was contradiction. This isn't the first time a high-profile defendant has faced this type of judge's ultimatum over bond requirements. Remember Bernie Madoff in 2009? After his arrest, Madoff's lawyers argued he should be released on bond secured by his Manhattan apartment. The judge rejected it, saying Madoff had shown a pattern of dishonesty. The key similarity is the judge focusing on credibility. When someone's public words contradict court filings, judges see it as proof of ongoing deception. Then there was the Enron situation in 2004. Jeffrey Skilling tried to use company stock as security. The court rejected it, noting that the fraud charges involved inflating that stock's value. The connection is obvious. If your alleged fraud involves lying about asset values, courts are suspicious of accepting those same assets as bond security. Subscribe immediately if you haven't yet. And let's not forget Trump's own previous bond issues in the E. Jean Carroll defamation case. At first, his team said they couldn't get the $5 million bond quickly. Then, when the judge set a firm deadline, the bond appeared within 48 hours. That pattern of claiming impossibility followed by sudden success has clearly influenced Judge Engoron's current approach. Now, though, the stakes are massively higher. We're not talking about $5 million, we're talking about $464 million. And this time, the judge has made it clear he's not playing the same game. The pattern couldn't be more obvious. When defendants claim they can't afford something while simultaneously showing off wealth, judges eventually reach a breaking point where accommodations stop. So what allegedly caused this extraordinary response from the judge? According to legal analysts, Judge Engoron's decision was driven by a basic credibility problem. Trump's attorneys claimed posting a bond this large was essentially impossible without using real estate. They cited industry rules requiring approximately $557 million in liquid assets for a $464 million bond. Here's the shocking part. Just 17 days before filing that motion, Trump appeared at a rally in Manchester, New Hampshire, where he stated, "I have almost $500 million in cash sitting in accounts right now." The New York Attorney General submitted the video clip as evidence. This wasn't a disagreement about policy. It was a direct factual contradiction between public statements and court documents submitted under oath. Don't go anywhere. The most explosive part is coming next. And here's what should concern everyone watching this case. This isn't just about one bond motion or one hearing. If defendants can make opposite claims about their money, depending on whether they're talking to voters or facing legal responsibilities, the entire civil justice system loses its foundation. Once courts decide they can't trust financial documents because defendants treat different forums with different levels of honesty, the result is that only the most aggressive enforcement actions work. At that point, there's no going back to trust-based talks or voluntary cooperation. This puts Trump in a nearly impossible situation. On one hand, he faces huge political pressure to maintain the image of massive wealth. His entire brand, his campaign message, and his appeal to voters depends on people believing he's an exceptionally successful businessman. Admitting he can't access $464 million contradicts that core story. That means he's motivated to keep publicly claiming substantial available wealth. On the other hand, he's forced to deal with actual legal requirements that demand turning those claims into reality. He now has to explain to his political supporters why, if he truly has nearly $500 million in accessible cash, he's fighting so hard to avoid posting it as bond. The contradiction isn't theoretical anymore. It's happening right now with a 4-day deadline. And here's the difficult part. There's no believable defense that solves both problems. Either Trump actually has the liquid money he claims, in which case his court filings claiming he can't post bond are false and potentially punishable, or he doesn't have that money, which means his campaign statements about his wealth were misleading. Legal analysts see this as a situation where Trump's strategy of maintaining different stories for different audiences has finally collapsed under a judge's examination. Legal and constitutional experts are calling this a turning point moment. Andrew Weissmann, former FBI general counsel, told MSNBC that Judge Engoron's approach represents a judicial response to what courts increasingly see as gaming the system. He explained that when defendants have resources to file endless motions, judges eventually must draw clear lines. The hard deadline with immediate enforcement removes the reason to keep filing delay motions. Joyce Vance, former U.S. attorney and University of Alabama law professor, told NBC News that courts work on the assumption that parties will be truthful in their filings. When that assumption breaks down because public statements contradict sworn submissions, judges lose patience quickly. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Turley, a George Washington University law professor who has often defended Trump, admitted the bond issue presents serious problems. He stressed that once a judgment is entered and appeals are pending, courts have legitimate power to insist on following standard bonding practices. So let's break down what this could mean. First, the immediate political impact is enormous. If Trump can't post the bond by January 27th, the Attorney General will start seizing assets. That likely begins with freezing bank accounts and putting claims on properties. 40 Wall Street and Trump National Golf Club in Westchester could face claims. The image of Trump properties being seized would dominate campaign news coverage. Second, it creates credibility problems with voters. Polling by Morning Consult found that 61% of Trump's supporters believed his net worth was over $5 billion. If he can't produce $464 million, that story collapses. Campaign advertisements are already being prepared with clips of Trump's wealth claims next to news of seizures. Finally, Trump faces several other cases where he may need bonds during appeals. The Georgia RICO case almost certainly will require one. If judges in those cases see this pattern, they can point to Judge Engoron's ruling and say, "We've seen this before. Provide proof or face immediate enforcement." Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal and political consequences, this is really about basic principles of equal justice. The American legal system works on the idea that court orders apply equally regardless of wealth or status. Bond requirements exist to make sure defendants don't simply run away or hide assets while appeals move forward. If wealthy defendants can avoid posting bond by claiming their wealth is tied up in assets they won't sell, while less wealthy defendants sit in jail because they can't make bail, the system loses legitimacy. Judge Engoron's ruling reinforces that bond requirements aren't suggestions or starting points for bargaining. They're obligations backed by enforcement power. This situation is causing absolute panic within Trump's inner circle. Sources told Rolling Stone that Trump's team has been making desperate calls to potential lenders over the weekend. Some advisors have suggested Trump sell a property to generate cash. Others argue that would be politically devastating. Meanwhile, Trump's core supporters are furious at Judge Engoron. Social media is filled with claims this is political targeting. They're calling for protests and demanding Republican action. To the base, this proves the legal system is being used as a weapon against Trump. Things escalated when Trump responded on Truth Social late Thursday. He called the deadline a complete joke and election interference. He claimed he had more cash than I need, but refused to reward a rigged system. Notably absent was any plan for posting the bond. Stay with me. Here's what makes the response even more revealing. Trump's post essentially confirmed what Judge Engoron accused him of doing. He claimed to have plenty of cash while at the same time saying he won't post it. That's confirmation of the judge's analysis that Trump is choosing not to comply rather than being unable to comply. When your public response is, "I could do this, but I won't," you've handed prosecutors the evidence they need. Barbara McQuade, former U.S. attorney, tweeted that Trump's statement was basically an admission of contempt. She explained that courts distinguish between defendants who genuinely can't comply and defendants who refuse to comply. Trump's post made it clear he's in the latter category. This goes far beyond one bond requirement in one civil case. It's about whether the American legal system can enforce judgments against defendants who have resources to wage endless procedural battles. If Trump successfully avoids posting this bond despite the court's final deadline, it signals that wealthy defendants can ignore court orders by filing endless motions. That precedent affects every future case involving powerful defendants. If this blows your mind, hit that like button right now. Here's the situation. A federal judge has given Trump until Monday, January 27th at 5 p.m. to post $464 million or face immediate asset seizures. Trump's public statements claim he has the money but refuses to post it. His court filings claim he can't access enough liquid assets. The judge has made it clear that this contradiction is why he's imposing a hard deadline with immediate consequences. Keep a close eye on this story. The New York Attorney General has reportedly identified specific Trump properties for potential seizure. Legal teams are preparing enforcement actions that could be filed as soon as 5:01 p.m. on January 27th. Meanwhile, Trump's advisors are split on whether to sell assets or challenge the court to follow through. Voters are watching to see whether the legal system can actually hold Trump accountable. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A federal judge just eliminated every escape route Trump's legal team had been using to delay posting a $464 million bond. He gave them until Monday at 5 p.m. to comply or face immediate asset seizures. Trump's response was to claim he has the money but won't post it, confirming exactly what the judge accused him of doing. Legal experts say this represents a judge finally drawing a line after months of contradictory claims and delay tactics. Meanwhile, the deadline is ticking down with no indication Trump plans to comply. This isn't just another news cycle that will fade away. This is a constitutional showdown unfolding in real time over whether court orders actually have power when defendants refuse to follow them. What happens at 5 p.m. on Monday, January 27th, could determine whether the American legal system can enforce judgments against politically powerful defendants, or whether enough wealth and political support create practical immunity from court orders. The evidence is in the public record. The judge's deadline is explicit. The enforcement tools are ready. Now we wait to see if judicial authority still carries any weight when confronted with the defendant who has made it clear he has no intention of voluntarily following through. The stakes have never been higher. The credibility gap has never been more obvious, and the constitutional crisis has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.